Hi, I'm Gail Eskridge. I've been an attorney for over 30 years. Until recently, I had a hybrid practice, meaning I represented my own clients in litigation in the areas of employment, business, and real estate law, and I also worked as an arbitrator and mediator in those same three areas. I've now stopped accepting private clients, and I work full-time as an arbitrator and mediator. I have offices in both Southern and Northern California, in Los Angeles County and Sacramento County, and I travel all over California all the time, and sometimes even travel to other states, arbitrating and mediating cases. If you're a party rather than an attorney, you may be wondering what the difference is between arbitration and mediation. The words sound sort of similar. Well, while they're both alternatives to court litigation, arbitration and mediation are very different from each other. Arbitration is more similar to court litigation than mediation is. In arbitration, the parties agree to hire a neutral third party to issue a ruling to resolve their dispute. In mediation, the parties hire a neutral third party, a mediator, to assist them in coming to an agreement to resolve their dispute. The overall goal of both mediation and arbitration is to resolve the dispute efficiently and economically, so the parties can get back to living their lives and running their businesses, rather than spending their time and energy thinking and worrying about something that happened in the past. In my experience, very few people actually want to be wrapped up in litigation. In this video, I want to speak specifically about mediation. Different mediators have different styles, but most mediators do a sort of shuttle diplomacy. They have the parties in separate conference rooms or separate virtual rooms, and the mediator goes back and forth talking to the parties. The role of the mediator is to listen to what the parties have to say and help the parties understand possible weaknesses in their case and apparent strengths in the other party's case. The mediator will often discuss with the parties the reasons why settlement is preferable to continued litigation or arbitration. In short, the mediator will attempt to persuade you what is best for you, considering all the circumstances. A mediator can never force you to settle. The decision to settle is always up to you and your attorney. As I mentioned, mediators have different styles. There are mediators who yell and even curse at the parties, slam doors and throw documents. It's all very exciting. With some parties, that may be effective. Other parties, however, are upset and even offended by that approach. I personally have a much more calm approach. I don't even think I could make myself yell at people. It's just not me. I can't imagine yelling at anyone in a mediation. I talk to each side about what happened, about how they feel about the situation, about what I see as the strengths and weaknesses of their case and the other party's case, and about the benefits of resolution versus continuing the fight. I won't provide legal advice, since mediators are not supposed to do that, but I will tell you, based on my 30-plus years of practice, what I would do if I was in your situation. Some cases don't settle during mediation, but if a good start has been made, they may settle during phone calls with counsel after the mediation, or there may even need to be a second day of mediation. Whenever the settlement occurs, the attorneys will prepare and agree on the terms in a detailed settlement agreement. The best case scenario is for the settlement agreement to be prepared and signed by everyone during the mediation. If that's not possible for some reason, at the very least, the parties should sign a memorandum of agreement during the mediation with the main bullet point items. I offer the following points of advice for parties attending a mediation. Drive to the mediation location in advance of the hearing and figure out where you should park. That way you're less nervous on the day of the mediation. If the mediation will be via Zoom, make sure all your electronics are in order. This means making sure your computer is updated and your camera, microphone, and speaker functions are all working. Review the facts of your dispute. This may mean reviewing a demand letter, a complaint, some depositions, or other documents. Be on time to the mediation, or be early. Nothing bad will happen if you're early, but it's not good to be late. Be well-groomed and dress nicely. You don't need to wear a business suit, but you should dress nicely and respectably. This applies to mediations which are via Zoom, as well as those you attend in person. Find out in advance whether lunch will be served, or you should bring your lunch with you. You may be sitting there thinking, well, that's the least of my worries. Well, it won't be in the middle of the afternoon when you're hungry and you're tired of being there. Depending on where you're having the mediation, sometimes lunch is served, sometimes snacks and beverages are available, sometimes only beverages are available, sometimes only water is available, and sometimes nothing is available. So ask your attorney in advance what you should bring with you as far as food and drinks. And if you have a medical condition which requires you to have snacks throughout the day, make sure to bring your snacks with you. If you need to take medication during the day, make sure to bring it with you. If you smoke, and I hope you don't, but if you smoke, bring your cigarettes. You're going to be sitting for a long time, so if you need to use a special pillow or back support, it's perfectly fine to bring that with you. If there's someone, such as a spouse or business partner, who will need to be part of the decision, either bring them with you to the mediation or make sure they're available by phone. During the mediation, be patient. I know it's difficult. Negotiations are generally not a straight line progression. There will be back and forth moves and probably even some moves which seem to go sideways. That's totally normal. You should think of the mediation as a dance rather than a race. Although I know this is much easier said than done, try not to get too angry or emotional. It'll just exhaust you and not accomplish anything. If you do these things, you'll have a good chance of a successful mediation. I would love to meet you sometime in a mediation. I hope you or your attorney will contact me. Thank you.